If you're an employer and want to make sure that your lawsuit filed against you by an employee for sexual harassment and retaliation goes to a jury, run your office like a locker room and then ignore complaints about it. I'm Karen Michael, and you're listening to The Job Judge. Welcome to The Job Judge, the podcast for anyone who works. I'm Karen Michael, your host of The Job Judge, where together we navigate through all those legal landmines and workplace dysfunction that I'll bet is happening in your organization. And our goal, of course, is to make workplaces work. Now, I am an employment lawyer, but I cannot give legal advice on this podcast. It really is just general guidance. And we do talk about sensitive subjects on The Job Judge. That is especially true today, where I am going to be talking about a sexual harassment case. I'm going to be sharing with you exactly the allegations, and they're kind of gross. So just a forewarning, this is adult content. Finally, especially if you're a manager, an HR professional, a business owner, you are not going to want to miss an episode. There's a whole lot of people in leadership that need this message. Hit the subscribe button so you don't miss an episode. If you're watching on YouTube or Spotify, listening on Spotify podcasts, wherever you get your podcasts, be sure to follow along. Let's talk about a recent case. Now, the case I'm going to talk about today came out in August of 2024, and it hits home to me because it's out of the United States District Court for the Western District of Virginia, and I am a Virginia attorney, so this case kind of hit home to me. Now, I'm not going to tell you the name of the parties because these are just allegations, and I don't want anyone to feel like they're targeted in their name, because they have a right to a defense in this case, and both parties have a right to put on their case. So, but I am going to refer to the plaintiff as MP throughout this case. It's a female who worked in western part of Virginia at kind of like a manufacturing plant, let's call it that. And she sued her employer for sexual harassment, hostile work environment, disparate treatment, gender discrimination, retaliation, retaliatory hostile environment under Title VII of the Civil Rights Act, which prohibits discrimination or harassment based on race, gender, national origin, color, or religion for an employer that employs 15 or more employees. She also sued under the Virginia Human Rights Act, which prohibits similar things based on employers in Virginia who employ more than 5 employees. And because the Virginia Human Rights Act and Title VII kind of track the same, the court analyzed this case on Title VII's allegations and causes of action, et cetera, and legal precedents. Now, this is the stage of the litigation. What happens is an employee sues their employer, and it goes through what's called discovery. And in federal court, at the end of that discovery, typically the defendant, the employer in these employment cases, will file what's called a summary judgment. And the employer is saying to the judge, look, judge, even if you take all the facts based on what the employee says has happened, there still is not enough evidence to win a lawsuit, because frankly, the burden is really high to win a federal lawsuit. And usually the judge will look at all the evidence in the light most favorable to the person that's suing and say, even if everything you say is true, there's not enough to win a lawsuit, or I think there's enough here. A jury should decide the final outcome. And that was the case here. That's the status of this case, is whether or not this case actually goes to a jury. And these are the facts. This woman, MP, started working for this organization in 2007. And this organization, she contends, employed very few women, and that female employees were sexually harassed and treated less favorably. Now, she recounted her allegations, and they are set forth in the lawsuit. So let's talk about what they are. They're kind of gross. So pause right here. If you are triggered by listening to allegations of sexual harassment, probably want to pause here, because I'm going to tell you what she alleged. She recounts several incidents that happened while a former plant manager oversaw the plant. During a manager's meeting, this plant manager allegedly passed around his cell phone to show a photograph of himself and then assistant plant manager, a male, dressed in penis costumes. Why? Why are you sharing this with people? He insisted that the photo be shown to MP. The two men also compared MP's buttocks to that of another female employee while the two female employees were present. Why are you talking about this person's appearance? The word buttocks, talking about somebody's butt in a workplace should not be discussed. That's on the never ever list. Lastly, this plant manager told the other male in front of MP and another female that children visiting his house had found a dildo and a condom he and his wife were saving for a special occasion. So nothing that she alleged should ever be happening in an organization or a workplace. But there's more. She contends that the work environment in the plant became increasingly hostile when the other guy that was referred to, not the plant manager, but the other guy that was referred to in those other conversations, he then gets promoted. So, hey, we talk about guy stuff and you get promoted, which he did in 2021. In late 2021, MP, this manager, and two male managers went to a pharmacy for COVID-19 vaccinations. At the pharmacy, this new plant manager now picked up a tube of cream used to treat vaginal yeast infections and said, MP, he used her name, I think you need this. He also told the pharmacist, MP needs a double dose of penicillin. Gross. Why are you saying that? She also described comments by production manager when he asked MP if she had a, quote, boob job and referred to her as a whore. FYI, the word boob should not be used in your workplace. I don't know who needs to hear this. That word has no relevance to your workplace unless maybe you work at a plastic surgeon's office. And even then, you really should be talking about the breast reduction or whatever you're talking about. But the word boob generally should not be. Oh, the only other exception is in a place that does mammograms. That may be the only other place that you'll be talking about boobs. And refer to her as a whore. Obviously, that should not be discussed. Well, in MP's presence, this manager and told two male employees of another guy, come on in, boys. I thought she would have her clothes off and we would have a foursome, referring to MP in her presence. I thought she would have her clothes off and you would have gross. The imagery of that, the implication of that. Everything I need to know about this workplace, I can know in knowing that that was said in a workplace and that no one stopped it. No one said, what are you talking about? What is wrong with you? No, it's a guys club. This is what we do. On a different occasion, he was speaking with MP about another employee's girlfriend. He said, if I had what you women have, I would sell it and make millions. He added the employee's girlfriend had already given it to everybody. On a separate occasion, a contractor entered this manager's office while MP was inside. He told the contractor to enjoy the scenery and pointed to MP. He commented that his office smelled like, quote, ass and boots. What a great place to work. She testified that she told multiple managers about all of this, that she told other people that this kind of behavior was happening and that she was offended. And she allegedly was told that they are going to retaliate against you if she reported it. And if she said anything to HR, that she would need to hire a lawyer. And she claims that after she made these complaints, that she received less of a raise than other people in retaliation for her complaining. So let's talk about her hostile working environment complaint. As I said, you need a lot to win a hostile working environment claim. So these are the elements. The employee has to prove that 1, the behavior was unwelcome. 2, it was because of her sex. 3, it was sufficiently severe or pervasive to alter the conditions of her employment and create an abusive working environment. And 4, it's imputable to her employer, meaning a manager or someone in charge knew about this behavior and didn't do enough to stop it. And frankly, that's where most of these cases fall out, is when managers know stuff and because they're either incompetent, indifferent, enjoying it, don't care, whatever it is, do nothing. to stop the behavior. That's when the money kicks in. That's when the liability kicks in. So the court looked at several things. The first thing they looked at is whether or not the behavior was because she was a woman, not just it was because of sex is a requirement under Title VII. And the defendant said that these behaviors and the offending conduct was not because of her sex. They said, for example, smells like ass and boots, picture of the penis costume, and the story about the dildo and condom, they're gender neutral. Everybody's talking about this. They also claimed that MP was not disciplined or forced to work from the office because of her sex, which is one of the things she claimed. They argue that the incidents are devoid of sex-specific terms targeting the female sex rather than her individually. And this is really important because this is what the court said. The judge said, I disagree. Statutory violations of Title VII do not require sex-specific taunts as argued by the defendants. That's so important because so many times I see investigators, frankly, do kind of a bad job investigating because they wrongly say, well, there weren't any specific comments towards MP. There wasn't a specific sexual behavior. That's not the test. The plaintiff's evidence produces an issue of fact as to whether vulgar comments and sexual imagery were aimed at MP because of her sex in order to, quote, make her uncomfortable and self-conscious as one of the few female employees in the plant. Check. She wins that argument. Let's go to a jury and let the jury decide. The second thing that the court looked at was whether or not MP showed behavior that was sufficiently severe or pervasive. The defendants argued that MP has only presented 9 unrelated incidents of rude comments and teasing as evidence. The court went on to recognize the test for severe or pervasive is both subjective, meaning I feel it is severe or pervasive, and objective, meaning a reasonable person. It requires a plaintiff to establish that she perceived and that a reasonable person would perceive the environment to be abusive or hostile. So it's not the I'm some triggered easily person. It's got to be a reasonable person would find this to be the case. The judge noted, I must consider the totality of the circumstances, including the frequency of the conduct, its severity, whether it is physically threatening or humiliating, or a mere offensive utterance, which is not included under Title VII, and whether it unreasonably interferes with the employee's work performance. The court went on to note that there is evidence that MP perceived the plant as a hostile working environment, satisfying the subjective element. Her coworker commented that MP frequently complained that she felt she was being treated unfair because they were women. She told another person, the director of HR, that the plant manager was very biased against her because she was a woman. And the court judge said, I find the conduct issue in this case is enough to raise at least a jury question. Let's let a jury decide whether or not the workplace environment was objectively hostile or abusive. For instance, the judge said comments about MP's appearance or her needing a vaginal yeast cream were made in the presence of others, presumably to humiliate her. By the way, that would also have been the case with the issue of the foursome. A reasonable jury could also find that sexual violence was implicated when the production manager told 2 male employees, come on in, boys, I thought she would have her clothes off and we would have a foursome. Check. You win that argument. Well, what about the notice issue? Managers, listen up. Listen up. I promise this is where you fall out. You've got to do something. Turning to the fourth element, the judge said, I must decide whether the conduct described is imputable to the employer. An employer is liable for harassment by MP's coworkers only if the employer knew or should have known about the harassment and failed to take effective action to stop it. The defendants first state that they are not liable for a hostile work environment since they took proper actions to prevent it, such as harassment trainings. Good job. That's a good argument. And placing a poster in the plant that explained the defendant's sexual harassment policy and directing employees to contact HR for complaints. But to escape liability, an employer must show that it took effective action to stop hostile work environment by responding with remedial action reasonably calculated to end the harassment. In assessing the employer's actions, courts look to the promptness of the employer's investigations when complaints are made. You've got to do something. You can't just sit back and Oh, you better not tell anybody because you're going to get in trouble. No, you need to investigate the allegations, whether offending employees were counseled or disciplined, and whether the employer's response was actually effective. Title VII only requires an employer that would take steps reasonably likely to stop the harassment. In fairness, you're not required to fire everybody that engages in harassment. I mean, I would, but you're not required to do that. You can discipline somebody, give them a final warning. The problem is, if that person reoffends, the EOC is coming after you much harder. So you're in bigger trouble if that person reoffends after you give a warning. So you better be sure this person's not going to reoffend if you just give a warning and don't terminate. The judge said the facts do not establish beyond dispute that the defendants took action reasonably calculated to end the harassment. When the harassment is serious, as it is alleged in this case, merely conducting trainings and placing posters is not sufficient. And they said the defendants also claimed that MP reported the harassment to powerless managers, meaning people that didn't have any power, but like just random shipping manager here and there. And the judge said a reasonable jury could find that the defendants had knowledge of the harassment because they were in manager positions. And so the court said, let's let a jury decide. Do we know what a jury is going to decide? No, it's up to a jury, but enough evidence is there. How much is this costing this employer? All the employer had to do was do the basic things. Have a policy. Yeah, they did do that. Share the policy. Yes, they did do that. Conduct trainings. Yes, they did do that. But all that stuff is meaningless if it's a big joke. If after doing all of that, it's just to check the box. It's not actually creating a culture that there is no harassment. All those things that you're pretending that you actually care about making sure that we have a harassment-free workplace, pretending is not the same thing as actually having a workplace that is free from harassment. In this case, on the one hand, you're doing training to make sure employees know that we don't allow sexual harassment. And on the other hand, you've got a manager joking about a naked employee having a foursome with two other employees or other people in front of other people, and no one bats an eye. No one is in shock and awe because we do this all the time. It's just what we do around here. It's a bunch of guys. See, that's what leads to litigation. Now, the other issue on the retaliation was also interesting because the employee was able to show enough evidence that she engaged in protected activity by complaining of the harassment, that she did not get the same raise as other people, and she said there was a causal connection between the two. And the court said, let's let a jury decide that as well. Now, the conclusion of the judge, I think, is the most important thing. And I just think it's a very interesting way to conclude. The judge said, it is contended that MP was merely the object of, quote, playful banter, end quote, who herself, quote, had a mouth like a sailor, end quote, and gave as well as she got. Well, if you're in this kind of work environment, you probably do feel like you got to do something to fit in. The judge said, that may be true. And it may be equally true that any adverse job actions she suffered were her own fault and not because of her complaints about her fellow employees' conduct. However, I find that the truth of those issues and other relevant matters in dispute must be decided by a jury as the Constitution provides. So there it is. So now this theory of playful banter can be put in front of a jury, and a jury can decide whether or not that conduct constitutes harassment. You know what would have been a lot cheaper and a lot easier is just to have a policy that you actually follow, that you actually make sure doesn't happen. And when there's a whiff of this kind of behavior, you stop it immediately. You don't allow it at all. And it doesn't matter if it's your buddy or your best friend or the most senior person. Everyone needs to feel safe complaining about this behavior without retaliation. The allegation is just was well known that you better not say anything or there's going to be trouble. That makes employees powerless to bring things forward. They're scared that something bad's going to happen to them. Instead of there being praise for employees that bring something like this forward, there's punishment. We can't have that. The way to eradicate harassment, leaders, is just take a stand, model the behaviors that you expect, and hold people accountable. There should be no question what those expectations are. And now it's time for Ask the Job Judge, where I answer a question that someone emails me at Karen@thejobjudge.net, or I see it on Reddit or somewhere on social media. People write to me all the time on TikTok. You can follow me on TikTok, by the way, with @thejobjudge on TikTok and Instagram. People ask me questions there. This particular question comes from the job site on Reddit, which I find to have some really good questions. The question is this: team sent me work while I was on bereavement leave and then followed up asking where the work was. Friends say I'm overreacting. Thoughts. This employee says, I started a new job fairly recently, like 2 months ago. And while it's bad timing, not that these things are ever well timed, my father fell extremely ill and died. I took about 6 days off because I truly did need it, being with him in the hospital at the end, the funeral, intermittent travel, basically came back to work as fast as possible with no real days to just process the situation. Every day was a day doing something or spent with family, actively taking care of arrangements. They, the employer, her new employer, gave her 3 days bereavement, one personal day, and then had me go into a negative balance on vacation days because she hadn't accrued, or this person hadn't accrued enough, which made me feel a bit weird, but I guess whatever. I figured since I'm new, it's awkward. The employee then says, while I was away for bereavement and my team was aware of why I was away, they were sending me work assignments. I feel like it's weird to be emailing someone with work when they're away for death in a family, but my friends, especially ones who work in corporate America, say it's normal and that they just expect you'll see the email when you return. However, it was overwhelming as I returned to nearly 150 emails. Some of the projects were a bit more work, and despite the fact that they were sent while I was supposed to be out of the office, I got messages, particularly from one person, asking why they weren't done yet. I said I wasn't finished yet as I was still working my way through everything, but they made a comment along the lines of, this needed to be done quickly because we were waiting on other people's feedback. Then in a meeting yesterday, this person says they made what I thought was an odd comment about, quote, I wondered if you were taking another long weekend. When I mentioned not doing much for Labor Day, my bereavement wasn't a long weekend for me or a vacation. Am I being too sensitive? This person asks. It's a new job and an environment for me, and I'm trying to figure out the dynamics. What I would say in response to this question is that, first of all, I'm so sorry. It is life changing when someone has a family member die, especially a parent. And it's people grieve differently. People have different needs. Some people have to fly out of town. Some people have to make all the arrangements. Some people are in charge of the whole thing afterwards and dealing with all the estate and probate and all those things. It's a lot. And whether you're a brand new employee, you're right, timing here isn't great, or you've been there forever, it's a lot. And we do need to be sensitive to the fact that people have personal things happen in their lives, and we should be sensitive. So I am so sorry for this person losing their parent, and people do grieve differently. And 6 days seems like a reasonable amount of time to be gone for your parent, especially if you were caring for your parent at the end of their life, and then after they died, you took more time. But I would also say that the work does go on. And when you come back to work, you need to hunker down and get your work done because the work didn't stop while you were gone. So it's not like you were gone for 6 days and there's this pause. And I'm not sure what this employee thought was going to happen, that all of a sudden you got back and nobody was going to send you emails while you were gone and nothing was going to get done. People were sending you emails so that when you got back, you would be able to answer, respond, because the work is still getting done. So I would say both parties are right because the employer, I think, did a good job of giving this employer their 3 days of bereavement leave. That's probably their policy. Letting this employee take that personal day that they had earned, good job, and letting that employee advance so they didn't go into an unpaid status. So the employer did a good job with that. So kudos to that employer. And the employee did a good job by coming back to work and reading the emails and getting back re-energized. But I also think both are at fault. It does sound like when the employee returned, the employer might have been a little frustrated. The employee is new. And so maybe the employer could have been more sensitive to the fact that this employee was out for a bereavement. And I don't think 6 days is unreasonable. And I think the employee is being a little overly sensitive by everything these people are saying, taking it personal and feeling like it's a personal affront to them. Now is a time to get back to work, come back. Let's not take everything so personal. Recognize that your employer did do a good job, didn't have to let you advance those days on your vacation, but they did anyway. So be grateful that the employer did do the right thing. And now let's get back to work, hunker down, and do what needs to be done, because being out 6 days probably did accumulate a lot of work, especially if you are a new employee and you probably are still doing your ramp up as well. So both parties are in the right, both parties are in the wrong. Let's move on. Let's show empathy to our employees. Let's also not be so sensitive and take everything so personal. Now, we drop an episode of The Job Judge every single week. You are not going to want to miss an episode of The Job Judge. So be sure to hit the subscribe button right now so you don't miss an episode. And be sure to watch every single week, share, follow, comment so you don't miss an episode. I'm Karen Michael, and you've been listening to The Job Judge.